My name is Kenise Dupree. I'm an exoneree who spent 30 years in prison for a crime I didn't commit.
I was incarcerated for 36 years for a crime that I didn't commit.
I show you how deep the rabbit hole goes.
Like you, be strong to hold the powers of the sun. Can I be your superhero?
Hello, welcome to The Revealing. I'm your host, Pavarotti, and I'm here to discuss the Idaho 4 case. And, you know, the last few days been pretty tough. You know, Pav's been pretty mad at the entire situation. And I'll be the first to tell you, that's why I held back on doing videos for a couple of days. And I said, let's just hold back and see what happens. And then when I watched that hearing and I watched Brian Kohberger say yes to he was guilty of going in the house and committing the crimes, I mean, I was really floored. And the only thought that I could have was, I mean, he was obviously one of the guilty parties in this, and he's admitting it. And why would I not believe the words that are coming out of his mouth? And I reacted to that, and I reacted pretty harsh, because anybody that was involved in the atrocity on King Road, I mean, I have zero respect for, and I want nothing more than damage to be done to them. And so when I put out the video yesterday, I put it out sincerely. Now, as I read my comments, which they were quite a few of them on there, and I read what everybody was saying, and I was kind of dumbfounded, thinking, wow, how can everybody still feel so strongly about Brian Kohberger being innocent? And then I realized that, you know, me and others have pointed out how the state's case is obviously wrong in this case. All the evidence does not lead to Brian Kohberger. It actually leads away from Brian Kohberger. And then, of course, I made the statement that as I was investigating this case, I would see ways where Brian Kohberger could do this, and I wouldn't report on it just out of respect for, you know, innocent until proven guilty. I didn't feel the need to pile on to somebody that was getting piled on before trial. And I know some people took that as I was holding back evidence of his guilt. And that's not at all what I was doing. I would see never, ever did I see any evidence that the state alleged matching up to Brian Kohberger. It all went in the opposite direction of Brian Kohberger. However, I would see ways where Brian Kohberger could have been involved and could have been at the residence, but it was outside of what the state was alleging. So I wasn't about to, you know, present speculative evidence against Brian Kohberger and pile on to him. So I've never, ever seen any of the state's evidence that lines up in any way. I was not going to speculate on anything outside of the state's evidence against Brian Kohberger, though. However, after reading so many of those comments and seeing how passionate everybody is, and y'all know how passionate I've been on this thing. I mean, I can sit here and say that, you know, I would see things that made me think Kohberger could have been involved, but I'm with y'all. Everything that I had seen went against the state's case, and I believe that he was factually innocent as well. And I'll tell you, as of right now, I still do. And it was because of the words that y'all kept putting down over and over that made me take a step back. And I don't know how many hours I've been at it right now, but I took a step back and I reviewed some things, and I said, okay, I've got to get some answers to some questions. I mean, here's the first question was, why would Kohberger do this if he was innocent? And the next question was, why would the state do this? Is there anything that's happened that lets us in on why something like this and how something like this could happen? And then looking at everything in the landscape around this. One of the things that was very interesting was the fact that Brian Kohberger's parents were in court yesterday. Now, we heard that this stuff just came about Monday afternoon. You know, they live in Pennsylvania. They're not an affluent family from what we've been told. So for them to be able to drop everything, get last minute plane tickets, and be able to be there at a certain time, it's quite remarkable in a way. It's quite remarkable that everybody was able to stop their lives and be there right on time. Maybe too remarkable. So I sat back and I said, well, let's dive in. Let's see. And you know, it's funny. Everything I'm about to show you, I've reported to you over the last couple of months. I mean, I've reported it all. I guess as I dive into this stuff, and I go in so many different directions because there's so many different aspects of this case that sometimes it's hard for me to even put together even what I'm bringing to you cohesively over time, because I do go in so many different directions and some things are just kind of slid in here and there. But I've reported all this to you in real time. And as I stepped back and I tried to figure out what's going on and what happened here, it became abundantly clear. And I now know why the state offered what they offered. And I know why Brian Kohberger accepted the offer, and I know why he would sit there and say that he was guilty when he is not. And it has nothing to do with firefighters and alibi witnesses. That's a stretch for even old Pav. It has to do with real things, real situations, and real events. And I'm going to show you why Brian Kohberger would sit there and he would say what he would say. I'm going to show you when he did it, because this didn't just happen. This happened over a month ago. And everything that's happened since then has just been smoke and mirrors in this case. But I'll tell you exactly when it happened, when it started, who started it, why he did it. And it's not right. And it looks like it's going to be up to us to prove this guy's actual innocence. But there's some things that are going to even make a lot of the guilters mad when I expose what I'm about to expose. And it should make those families really mad that really wanted justice, because of the deal that the state forced Brian Kohberger into is certainly not a deal that they told them about, I assure you. Get ready. I'm going to show you why Brian Kohberger took that plea and said what he said. I'll show you exactly when it happened, and there'll be no more questions about this. Pav was wrong. Sorry, Kohberger. You were put in one heck of a bad spot, and looks like you took the easiest way out you could. And if I was in your shoes, I probably would have considered doing the same thing. Let me show you what happened in this thing. This is the date that Josh Hurwit was mysteriously inserted into this case. And it's not just his involvement in being inserted into the case, but it's specifically what his role was once he was inserted into this case. And when we focus on strictly what Hurwit was involved with in this case, it becomes abundantly clear what his role was. The first motion we seen attached to Josh Hurwit was this motion to seal the state's motion for examination of defendant pursuant to Idaho Code 18207, and for an extension of time to complete rebuttal penalty phase expert disclosures, declarations, and exhibits in support. And this motion was filed by Hurwit on the 25th day of April, 2025. And it's the time frame in when all of this was happening and the other things that were happening around it lets you know exactly what was taking place. But what was he looking to do? He was looking to independently analyze Brian Kohberger with state's psychologists for psychological, psychiatric, and neurological information. And they wanted the state to have a diagnosis of the defendant. And what's interesting is I reported on sealed motions later on. And y'all remember when the defense put in a request for discovery, it was their 23rd supplemental request for discovery. And that's when all the sealed things were happening in this case. And we couldn't figure out exactly what that 23rd supplemental request for discovery was, but we knew that it had something to do with exhibits that the state responded to that with, which I brought up several times. I said, look, the state has responded with a response that's sealed, but then the state responded with a supplemental response. I said, look, the state has responded twice to just one supplemental request. It's very strange. And in the second response, they attached exhibits S1 and S2. I said, wow, this is really weird. They're double responding to a motion for a request for discovery. And in the second one, they're putting in this S1 and S2. And then all of a sudden, we had a motion for independent analysis of evidence. And we couldn't figure out what it was, and we speculated on what we thought it might be. Well, let me tell you, everything that we were thinking that we knew was wrong. And I don't believe I missed a document. I believe they've inserted a document that they previously hadn't inserted and showed me what all this was about now that I went back and reviewed everything. This 23rd supplemental request for discovery was actually getting the psychological evaluation that the state did. That's what they meant by the independent evaluation of evidence that was sealed. State's exhibits S1 and S2 was this report. And this report, it turns out, is very important for the state, and it's also very important for the deal that they forced Brian Kohberger into. And I'm going to show you that deal here in just a minute. But as we look at when all of this was taking place, I can tell you they already had a deal in place when all of this was taking place. You see, this posted to the docs yesterday, 7/2/25, and this is the written factual basis of the charges. And it says, I hereby admit to responsibility to count 1, burglary, which requires the following elements. On November 13th in Latah County, state of Idaho, the unlawful entry of a residence at 1122 King Road, Moscow, with the intent to commit the crime of unaliving. Then, of course, it was all of the unaliving charges with the same language. On November 13th in Latah County, state of Idaho, the willful, unlawful, deliberate premeditation with malice aforethought, unaliving, and unaliving Maddie, Kaylee, Xana, and Ethan. I plead guilty to counts 1, 2, 3, 4, and 5 of my own volition. And then it's signed Brian C. Kohberger. And it's dated the 1st of July 2025? No, it's dated the 1st of June 2025. And let me tell you, with a legal document, if they put a line through it and write in something else, and there's no initials next to that line, then this is not a legal document. In any business I've ever been in, if you draw a line through a word and you write out another word, you and the person signing it have to put initials next to it acknowledging the error, or else it is factually not legal. So that tells me because they didn't take the time to change this in their actual document to July, which would have required, just simply hitting print one more time. And they did all this. And then as they're exposing it to us, they went, oh crap. And they just put a line through it and drew the word July. That tells me this thing was done June 1st, 2025. They're just letting us in on it now. With that in mind, and when we go to what has really happened right here, things become abundantly clear. Let's see. There's the notice of Hurwit on April 2nd. There's April 25th when they requested the psychological evaluation. And other than the motion to continue, Hurwit wasn't involved in any of the other litigation other than this psychological stuff for some reason. But this right here is the document that I either missed before or they've slipped in on us. And that was this motion to seal exhibits attached to state supplemental rebuttal disclosure, RE penalty phase expert Dr. Jason Gage. And in this one, that's why I don't know how I missed it, because it's clearly written out in here that this is an order sealing exhibits S1 and S2 attached to the state's supplemental rebuttal disclosure for penalty phase expert Jason Gage, filed on May 27th, 2025. Exhibit S1 is a neuropsychological evaluation completed by Dr. Gage. Exhibit S1 contains private medical information which is exempted from public disclosure pursuant to Idaho Code. Exhibit S2 is his curriculum vitae, which is also exempt from public disclosure due to Idaho Code, and or B, and A and or B, and like filings have been sealed by this court. So on the 27th of April is when they got this report back from Dr. Jason Gage of this neuropsychological evaluation. And here's what is important about this, because I'm going to wrap this in a bow when I'm done. But the reason that Dr. Gage had to do this evaluation is because of the initial evaluation that the defense did with their experts that diagnosed Kohberger with autism, OCD, and ADHD. And when we go to this document, the order on the state's motion for the 18207 examination and extension of deadline, and we come down here and it talks about, because the motion was likely to and did generate discussion about issues concerning defendant's mental health, including matters not admissible at trial, the court sealed the hearings. And to protect both the disclosure of highly intimate facts, which would be highly objectionable to a reasonable person if disseminated, and to preserve the defendant's right to a fair trial. Sealing the hearing was the least restrictive way to protect the privacy interests at issue. Neither party objected to sealing the hearing. Yeah, and what was this hearing about? It was about the court will allow counsel for both sides to watch the examination through a one-way video feed or some similar method that prohibits them from being seen or heard during the examination. Under no circumstances will counsel be allowed to interrupt the examination. So this was all about the state's independent analysis by their expert of Brian Kohberger. And then I know we mentioned this, that the state's motion for examination, they wanted an extension of time to complete the rebuttal penalty phase expert disclosures, and he granted that in part and denied it in part. But this was on the 6th day of May. And why am I going through all this? Basically to tell you this. On June 1st, their deal was done. They made the deal with Kohberger. Kohberger accepted the deal, and he accepted it because of something I told y'all a while back, and it's code 18207. Here's what they did. Remember, Hurwit comes in and he immediately files this first motion and puts it into play for Idaho Code 18-207. Josh Hurwit. This is why they brought him in, to clean up this mess. Title 18, Crimes and Punishments. Chapter 2, Persons liable, principles, and accessories. Persons liable, principles, and accessories. You know what that means? The person who committed the crime and anybody that was an accessory to the crime. But specifically, 18207 deals with mental condition, not a defense. Provision for treatment during incarceration. Reception of evidence. Notice and appointment of expert examiners. Number 1, mental condition shall not be a defense to any charge of criminal conduct. Well, we knew that. 192523. If by the provisions of section 192523 Idaho Code, the court finds that one convicted of crime suffers from any mental condition requiring treatment, such person shall be committed to the Board of Corrections or such city or county official as provided by law for placement in an appropriate facility for treatment, having regard for such conditions of security as the case may require. In the event a sentence of incarceration has been imposed, the defendant shall receive treatment in a facility which provides for incarceration or less restrictive confinement. In the event that a course of treatment thus commenced shall be concluded prior to the expiration of the sentence imposed, the offender shall remain liable for the remainder of the sentence, but shall have credit for time incarcerated for treatment. Nothing herein is intended to prevent the admission of expert evidence on the issue of any state mind which is an element of the offense, subject to the rules of evidence. No court shall, over the objection of any party, receive the evidence of any expert witness on any issue of mental condition, or permit such evidence to be placed before a jury, unless such evidence is fully subject to the adversarial process in at least the following particulars. Notice must be given at least 90 days in advance of trial, or such other period as justice may require, that a party intends to raise any issue of mental condition and to call expert witnesses concerning such issue, just like the defense filed in their motions in limine for the psychological and neurological diagnosis by their expert. So once the defense gave notice of that, such issue, failing which such witnesses shall not be permitted to testify until such a time as the opposing party has a complete opportunity to consider the substance of such testimony and prepare for rebuttal through such opposing experts as the party may choose. A party who expects to call an expert witness to testify on an issue of mental condition must, on a schedule to be set by the court, furnish to the opposing party a written synopsis of the findings of such expert or a copy of a written report. The court may authorize the taking of depositions to inquire further into the substance of such reports or synopsis. Raising an issue of mental condition in a criminal proceeding shall constitute a waiver of any privilege that might otherwise be interposed to bar the production of evidence on the subject, and upon request, the court shall order that the state's experts shall have access to the defendant in such cases for the purpose of having its own expert conduct an examination in preparation for any legal proceeding at which the defendant's mental condition may be in issue. The court is authorized to appoint at least one expert at public expense upon the showing by an indigent defendant that there is need to inquire into questions of the defendant's mental condition. The cost of the examination shall be paid by the defendant if he is financially able. The determination of the ability to pay shall be made in accordance with Chapter 8 and Title 19 of the Idaho Code. If an examination cannot be conducted by reason of the unwillingness of the defendant to cooperate, the examiner shall so advise the court in writing. In such cases, the court may deny the party refusing to cooperate the right to present evidence in support of a mental status claim unless the interest of justice requires otherwise, and shall instruct the jury that it may consider the party's lack of cooperation for its effect on the credibility of the party's mental status claim. So, in short, what happens whenever a defendant is convicted of a crime and he suffers from any mental condition requiring treatment? Such person shall be committed to the Board of Corrections or such city or county officials as provided by law for placement in an appropriate facility for treatment, having regard for such conditions of security as the case may require. That means once Kohberger's team filed the motion in limine for the psychological and neurological evidence of the diagnosis, and Hurwit comes in and files an independent evaluation by the state's expert, if the state's expert came back and agreed with the defense expert that Kohberger had any type of mental condition, that means that at that point, Kohberger's placement after his admissions of guilt is never going to be in the state penitentiary. It's going to be in an appropriate facility for treatment. This is how they forced Kohberger into the guilty plea. The Idaho Maximum Security Institution in Kuna, Idaho, houses the state's most disruptive male residents, including those under the sentence of death and those in the state's secure mental health facility. The IMSI also operates the Idaho Security Medical Program, the ISMP. The Secure Mental Health Facility provides care for individuals with serious mental illness who are involuntary or in involuntary treatment and may display violent behavior separate from the general prison population. But remember this Idaho Security Medical Program, because that's what it operates, and that's for inmates in involuntary treatment with displaying violent behavior. We know Kohberger's not going to display violent behavior, and he is most certainly going to be in the ISMP, the Idaho Security Medical Program, and we can bet because of Josh Hurwit in the deal that he's forced him into that he is not going to be anywhere near the IMSI in Kuna. Further investigation tells me that in Idaho, individuals convicted of murder with diagnosed mental conditions have been historically sent to the Idaho State Hospital South. This facility, initially known as the Idaho Insane Asylum, was designed to treat individuals with mental illness, including those who had committed crimes. In more recent times, some individuals with mental illness may also be placed in the prison system, particularly if they have a history of violent behavior. Well, we know that since Kohberger has been incarcerated in the jails, he has no history of any violent behavior. Yes, some convicted murderers with mental conditions may be housed at the Idaho State Hospital South. While the hospital primarily serves individuals civilly committed due to mental illness, it also houses individuals convicted of crimes who require mental health treatment. These individuals are placed in facilities that can provide both treatment and appropriate security measures. The Idaho State Hospital South, along with a women's prison in eastern Idaho, participates in the Idaho Security Medical Program, the ISMP. This program houses both individuals civilly committed for mental illness and those convicted of crimes who require treatment for their mental conditions. So there is no doubt in my mind where Kohberger is going to be sent. It's going to be to the Idaho State Hospital South. And when you look at the Idaho State Hospital South, it is not like any prison that you will ever see. It is literally a little hospital, maybe not little, but it's a hospital where you can imagine Kohberger is going to flourish in here because of his background and education. So would he take a deal, risk being sent to the death row where you're in a cage with no exercise, no anything, on a concrete bed for 20 years waiting to be executed? Or if he was given a deal to where he could spend the rest of his life in a very nice state hospital where he could actually use his skills and abilities to help people, yeah, I think he would take the deal if it wasn't looking good for his case. And I believe Josh Hurwit would be the one who could come in with the power to not only make the deal, but make sure that the facility that Kohberger was going to be sent to was predetermined. I'll admit I was pretty mad and closed-minded at the turn of events and hearing Kohberger admit to those crimes. And man, I mean, I was just shut down thinking, all right, buddy, if you had a part in it, then you deserve everything you get. And after reading all those comments, it really made me think, and it really made me deep dive. And then once I gathered my thoughts about Hurwit, who I just put a video out of him being the elephant in the room, and then I focused in on just what he was involved in the litigation in this case. And it was almost entirely around the neurological and psychiatric evaluation, and knowing, because I already did a video on what that triggers when you do that. And if you are diagnosed with a condition, what the outcome is on that. I should have put two and two together. But then going through all of the documents and when this took place, this deal was made back at the end of May, probably middle May, solidified in June. All they did was change the date from June to July on that document that Brian Kohberger signed, just to say that this all happened spur of the moment. Now, it happened exactly when they wanted it to happen. And Kohberger, I mean, I can't say I blame him. He was going to have his parents. You listen to Howard Bloom, he'll talk about how he did not want his parents to have to testify in this case. And that was one of the things that pushed him over. He wouldn't have known that his parents were going to have to testify until he received the exhibit list from the prosecution, which is right before this deal happened when you look in the case record. So with all that pressure on him, a deal like this being presented to him by somebody like Hurwit with the power to make it happen, yeah, I can see where he would take the deal. So Pa was wrong again, and we just got to keep our eyes and ears open when they release as much evidence as they can possibly release in this case to go through and find. We'll know once the evidence is released. We'll be able to see because we've looked at so much in this case. I know exactly what to look for. So once this evidence is released, if we can find evidence that undoubtedly proves Brian Kohberger's innocence, then I'm sure there's a way it can be brought to the justice system to fulfill an exoneration of Brian Kohberger. Maybe that's why he said when he was arrested, he looks forward to being exonerated. Please like and subscribe to the channel. Post your comments, thoughts, criticisms, and until next time, Pavarotti's out.